maybe you can take us back to a time before you had fought and won this PSAC case with the Supreme Court. What was the situation for public service workers in terms of their political rights at that point?
Well, prior to about 1991, when the Supreme Court decision came down, public employees had no political rights. This went way, way back. Originally, they were denied or rights were taken away from them in the 1880s when each ministry had about 4 or 5 people who worked for it, and it was thought that the minister shouldn't have political opponents in his very nest. And so that was the origin of that. And there was some concern along the way that public employees could be pressured to go out and canvass for the minister that they worked for, and so on. And so during World War I, when there was a joint government, the Liberal Party and the Conservative Party jointly governed Canada, the Public Service Commission was set up to create independent criteria and for employment. And at that time it was thought that the public service should be independent and it should not be partisan. It should not work for either one party or the other. And there weren't really any third parties at that time, or there were small parties, but no one was represented in Parliament, I believe. In any event, so that was the situation up until the introduction of the Charter of Rights. In the United States, they still have a public service that has no political rights. And in Britain, in 1948, which was after the Labour Party came into power after World War II, that was the first time that they liberated the public service. But in Canada, nothing had been done. And so basically the Public Service Employment Act, Section 32 at the time said no employee and no deputy head may work for, against, or against a political party or candidate. And then they had a proviso that you could actually give the candidate money or the party money, but you couldn't be seen to be partisan. This was the concern. You could be seen to be partisan. By the time I became involved in this, the whole money thing made no sense because people giving more than a small amount of donation appeared on a list, and so it was no longer a private thing, and so it was just as public as anything else. So that was the situation at that time, no political rights, to the extent that I used to get people talking to me about this who would say, I'm running for Parliament in Toronto, and the Public Service Commission has said that I can't have my wife in a picture on the back with my kids because she's a public employee, and that might be thought that she is supporting me in my candidacy. And so they were very ridiculous about it, and people got denied all sorts of rights, and that's kind of what led us to the decision that we had to challenge it once the charter came into effect.
Was there a specific incident that acted as kind of the catalyst for that, or?
Well, what happened to me was that Michael Cassidy, who at that time was a member of the provincial parliament in Toronto, approached me, and he was running as a candidate in Ottawa Centre. And he was being told at the door, oh, gee, I like your platform, I like what you're doing, but I can't lift a finger for you. And he felt it was unfair because, according to him, the Conservatives could get money, the Liberals could get money, and he was really just looking for workers, and they'd say, oh, the law prevents me from doing it. And so I said to him, well, it doesn't make any sense, and under the charter, it's very unlikely that that would be upheld, but it's just a matter of whether you want to challenge it or not. And if we did, you'd have to have some people, you'd have to show me some people who actually would like to work for you and do feel that this law is unfair. So he disappeared, and he came back 2 weeks later, and he had 5 or 6 people whose names I could give you if you want. I interviewed them all, and they were all gung-ho and wanted to do this. The situation in the public service is that, of course, constitutionally, we have to have an independent public service. We don't want a public service that gets mobilized on behalf of the Conservatives, that they go out in their spare time and campaign. So public service as a constitutional principle has to be independent. And so then the question is, what kinds of actions actually threaten that? If somebody is pictured with his wife on the back of a campaign sheet, would anyone reasonably think that the independence and impartiality of the public service is in jeopardy? In other words, the programs that the public service is articulating for the public, would they be prejudiced by that kind of a political action associating with your husband during his campaign? So we saw right away that the trick here was that most public employees do not have substantial discretion in their workplace, and they also don't have much in the way of a public profile. I think everybody can understand that if you're the assistant deputy minister, you can't be out campaigning saying, you know what, the government's program is just crap, and the reason I know is because I'm the assistant deputy minister. That person is no longer useful to the public service, and it's pretty clear that that would be a violation. But when we brought our case, we got all sorts of nice examples of people. For example, there was a fellow who examined bees for certain diseases. And so the question was, well, if this guy is a liberal or a conservative or a New Democrat or indeed a Bloc Québécois, would his examination of bees change in any particular way? And the reality is it wouldn't. And no one could reasonably think that this guy is going to his job every day saying, oh, I'm going to examine the bees in a way that advances the conservative agenda. So we got a number of those that were pretty ridiculous, mostly. One fellow, Ken Clavette, who I think was later head of Labor Council, at the time his job was to make sure that certain bureaucrats had pencils and erasers. And again, what's he going to do? He's going to prevent the bad guys from getting their erasers, you know. And so it was pretty clear that a lot of people are kind of below the radar, and there's no good reason for them to be politically controlled.
Can you take us through how this kind of played out in the courts?
Absolutely. So we had affidavits from each of the people. They were examined, they were cross-examined on their affidavits. And after that happened, we appeared in the federal court. First of all, I should say we tried to get an injunction. We were unable to get an injunction. What we wanted to do is say, stop this law. It's obviously unconstitutional, and we'll litigate later, but it's pretty clear it's unconstitutional, so don't enforce it because there's an election coming up. And the federal court trial division, Justice Jerome, said, no, we better leave it in, you know, and we'll see. It's only 200,000 public servants denied their rights, so we won't do anything. But later we went to the federal court, and we had a hearing before Justice Walsh in the federal court. It took about a week. He made a decision which was pretty odd, and just to give you an idea of how odd it was, he said in his decision that he had no power to strike down the section. Well, that's pretty amazing because the charter had been in effect for about 4 or 5 years, and he didn't think he had that power when he obviously did have it. Justice Walsh was a very knowledgeable person, but his specialty was admiralty law. And so that has to do with sunken ships and whose rights are involved and so on. And so we felt he wasn't the best justice, but he did decide partially in our favor, but on very odd grounds. And if I had to give you what I thought he actually did, he kind of let the nice, pretty young ladies have political rights, and the guys got told, no, you can't have those rights. In other words, it didn't make any conceptual sense why you could go door to door on behalf of the political party, but you couldn't stuff envelopes, that sort of thing. So I didn't see any real principle behind it. The government appealed, and so the Public Service Alliance of Canada supported me and us in our appeal as well. We were successful in the Federal Court of Appeal. They kind of dissed Justice Walsh's decision, and they decided that the section was unworkable because the words of the section were that it was unlawful to engage in work on behalf of a political party or candidate. And the Federal Court of Appeal said no one could possibly make any sense out of the words engage in work. It's so vague that it can't possibly limit a charter right. If you're going to limit a charter right, it has to be very strictly set out so people know what the limit is. So the Federal Court of Appeal agreed with us. The government appealed to the Supreme Court of Canada, where we were successful. I think that it's a pretty interesting decision, and if people are sort of interested in going there, it's called Osborne. That's the name of one of the appellants, Osborne versus Treasury Board. It sets out very clearly what the reasoning is, and basically they say that the old section, Section 32, the one that we were attacking, maybe it had a motive that was appropriate, keep the public service independent and nonpartisan, but it was not carefully crafted to reach that decision. And if you don't craft something carefully, what happens is that you get many, many more people than necessary. What's the point of having a law that's so broad it denies rights to people when there's no need? There's no need. And so that's what the case is about. That if you are going to take rights from someone for some gauzy constitutional principle, you better make sure that it's necessary and that only those people are deprived of their rights who, in fact, must be in order to achieve the appropriate objective. So,
I want to one final question for you around kind of culturally what impact you think this has had. Do you think that just raising awareness of the idea that public servants can engage politically had value? Do you think that clarification of the rules made people more confident in their political actions or engagement?
Well, if you read the section as it now reads, I'm just going to read the first bit of it just to give you the flavor. After the Supreme Court dealt with this, so here's the new section. The purpose of this part is to recognize the right of employees to engage in political activities while always maintaining the principle of political impartiality in the public service. An employee may engage in any political activity so long as it does not impair or is not perceived as impairing the employer's ability to perform the employee's ability to perform his or her duties in a politically impartial manner. So you see, it's completely reversed. Now the purpose is to protect the rights of public employees, and there are some limitations. And in fact, I think this is actually overbroad itself. In other words, I would say it can't be just, what do they say? Not perceived as impairing your abilities. It's got to be not reasonably perceived as impairing your abilities to do your job. So it's completely reversed. Now, do I think there's been an impact? I think there was an impact. It actually the Supreme Court decision came out about 10 days before Election Day in 1991. Michael Cassidy was elected partially as a result of this. He won by 54 votes, so he did call me up and tell me that the case made the difference to him. And for a while there was organizing around it, and public employees were kind of pumped, and yeah, we can do this, and yeah, we've got rights like anybody else. My impression is that slowly the air has gone out of the balloon, and over time, new people come in, they may have different priorities or whatever. My impression, and I don't interact with public employees every day, but my impression is that the wind has turned into calm. That's what I would say.